have the...
Right, but you just made a different point. What you just said is that that it should be treated the same as any other licensed vehicle on the road. That if you're going to ride a motorized wheelchair and it's not licensed, well, it should be treated differently. Well, I'm saying there are other motorized vehicles on the road that aren't licensed. Tractor trailers included, right? Those are not licensed. You could have a tractor trailer on your farm, and that's not a licensed vehicle.
A tractor trailer wouldn't be licensed. The response submits that part of the argument is that there is a difference between motorized wheelchairs and motorized vehicles, and this is why there is the difference between.
Okay.
So I'll draw your attention to paragraph 10 of our factor. The particular circumstances of the case are that Mrs. Smith was using her motorized wheelchair to directly cross the parking lot of the pub to get home. Mrs. Smith's husband was walking beside her, and he also appeared intoxicated. However, a breathalyzer test was not administered and no charges were laid. In the Crown versus Floyd, the court held that even if the vehicle is unable to be driven because it is out of gas, the intoxicated driver passed out in the front seat could still be considered to have care and control of the motorized vehicle and would be guilty under Section 253 of the Criminal Code. For Mrs. Smith, what this means is so long as she is seated in her motorized wheelchair and drinking an alcoholic beverage, she would be guilty of the offense, even if she was not in motion. This also eliminates the possibility that Mrs. Smith could self-propel herself home or her husband could push her home at the end of the evening because she's still seated in the seat of the wheelchair and would be in care and control.
Counsel, I mean, you're asking us to draw some awfully fine lines here with Shanahan, that he was able to walk 100 or 150 meters. Maybe the speed limit was lower. I mean, the parking lot accidents happen in parking lots, and often serious accidents. These are really, you're submitting that there's a real distinction here, and not simply that Shanahan was wrongly decided.
From Shanahan, I'm drawing a few conclusions, mainly that they say an able-bodied person would be, if they were found in an intoxicated state, that they would be charged with mischief.
But also, paragraph 11, you're drawing a distinction on the basis that Mr. Shanahan, as he submitted in your oral argument earlier, that the case is different because Mr. Shanahan was able to walk up to 150 meters. I mean, that's quite a fine line.
150 meters would have him be able to go into the bar, sit down, walk through the...
Well, clearly not everybody who's has limited mobility lives within 150 meters of the bar.
No, but that would allow him to find another means of transportation. Like in Mrs. Smith's case, they are in Fredericton. There is taxis for able-bodied person available outside of any bar.
And there are no taxis no accessible taxis? That I mean, that's a matter of fact, and we don't have any evidence on that.
No, I'm not submitting that story. What I'm saying is that for Mrs. Smith to leave the bar to get to a taxi, she is in care and control of a motorized vehicle on a public roadway.
I'm not sure about that. I mean, normally I would have thought that an accessible taxi pulls into a driveway or up to a sidewalk.
But so to leave into the driveway, yes. So all Mrs. Smith is doing is going to cross that the parking lot. If she could have been stopped at any point.
I mean, if she called an accessible taxis, there's nothing I see to suggest that the taxi wouldn't have been able to come to the pub itself.
Yes, to the pub. And
even if she would have had to use her wheelchair to get out of the pub to the taxi, I don't see any reason to think that she would have had to be on any public road.
The public road would be defined as like a highway means entire width of the boundary lines of every street, road, lane, alley, and parking lot. So that would be part of any boundary would include. And she could be charged at any point on that.
Well, it's just not clear to me that she would have to be in the parking lot. I mean, I don't know the ins and outs of Shepherd's Pub, but just as a matter of general pubs are often next to a sidewalk and sidewalks next to a street. And personally, when I walk into a pub into a taxi, I walk across the sidewalk and never step on the road. And I'm not sure why Mrs. Smith would have necessarily be in any different position. I mean, if it is true that the Shepherd's Pub in particular, you have to actually get onto a public road to get into a taxi, that would be quite unusual.
But the sidewalk, she could be charged as well. That's where Mr. Shanahan was charged, was on a public sidewalk. So long as she exits the pub, if she's on the sidewalk and has to and onto the parking lot, at any point she could be charged. So I'd like to draw back to the factum at paragraph 16. I'd like to consider the actual effect of the mandatory minimum sentence of Mrs. Smith. It's clear that the sentence doesn't allow the court to take into consideration the personal circumstances of the offender in the case-specific circumstances that would likely reduce Mrs. Smith's sentence.
Sorry, did you say it does or does not?
Does not. The mandatory minimum does not.
Oh, okay. The mandatory minimum.
Yes. The penological goals of the mandatory minimum sentence for being convicted of a third offense is aimed at deterring those who are already convicted of reoffending and from causing harm to society. The respondent has submitted that this is not a third offense and the mandatory minimum should not apply. So there are alternative sentences for Mrs. Smith.
Sorry, this is not a third, it's not a third offense?
Based on my argument, no.
It is, no, isn't your argument that it is a third offense, but the punishment itself or the sanction is cruel and unusual? Isn't that your argument?
My argument flows from that.
This is an offense, right? There's no question that she broke the law, that she is in violation of section 253 of the code.
Right. Yes, the respondent submits that because it's not a traditional motorized vehicle, that the third offense should not be considered a third offense to warrant a mandatory minimum sentence.
So she broke the law, but the sentence is wrong.
Right. Based on Shanahan, where the court stated that had Mr. Shanahan been...
No, I'm afraid I'm having a little bit of difficulty with this. Your submission then is, as I understand it, apart from any charter consideration that as a matter of the interpretation of the text of the Act, we should not consider this a third offense for the purposes of the subsection requiring mandatory minimum. Is that your submission?
I'm sorry, could you repeat? Did you say that it's not? I'm saying
So
that it's not.
suppose that the charter didn't exist. Is your submission that on these particular facts she has not committed a third offense such as to trigger the mandatory minimum on the text of the Act?
No, I'm using this argument as why it breaches section 12 and why it shouldn't be considered a third offense.
So it is a third offense. And the question is whether the mandatory minimum is unconstitutional.
Right, yes. Based on Shanahan, where the court stated that had Mr. Shanahan been an able-bodied person walking home in an intoxicated state, he would have likely been charged with mischief or a similar offense. Guided by section 15.1 of the charter, Mrs. Smith should have been charged with mischief. As a first-time offender, she would not be subject to a mandatory minimum sentence, and punishment would depend on the nature of the offense.
Counsel, I read your arguments on this, and I guess where I'm stuck is, so in Shanahan, they do a thorough section 15 analysis. The trial judge looks at section 15, does the law analysis.
Yes.
And it seems to me you're trying to differentiate Shanahan without doing the section 15 analysis. Is that?
I'm using the respondent submits that the trial judge stated that because Mr. Shanahan was not confined to a motorized wheelchair, that section 15 was not breached, and that's all that the respondent has for.
So you're not alleging section 15 breach in this case?
No, just guided by the principles as the trial judge stated should be done. So I'll direct your attention to paragraph 22 of the facto. While other crimes that result in mandatory minimum sentences are the most morally offensive, Mrs. Smith does not fit into this category. While Parliament intends to punish drinking and driving due to the high likeliness of harm caused to society, it is not likely that Mrs. Smith could cause the same degree of harm.
Now, counsel, so here we're looking at this mischief and the idea that she was pretty much walking. I'm not really persuaded that there wasn't a lot of potential for harm because even, let's suppose, an ordinary bicycle without a motor, driven on a public road by somebody who's drunk, has great potential for harm, as the appellants pointed out, simply by other drivers on the road swerving to avoid it. So maybe the problem here is that there is a lot of potential for harm, even from drunk walking down the highway. If somebody walks drunk down the middle of a freeway, I would expect death to follow, maybe by that drunk person, maybe by somebody else. So simply because Parliament has chosen to draw a line here to say, well, walking isn't quite as bad as motorized vehicle, it doesn't mean that drunk walking on a highway or drunk cycling on a highway isn't also deserving of a fairly serious offense. It's just a matter of we have to draw the line somewhere.
I'd like to draw your attention back to the facts of this case where she's in a parking lot, where the speed of the driver should be reduced. They should be aware that they're in a parking lot of a pub at 11:30 at night where intoxicated individuals are likely to be around. And the New Brunswick Motor Vehicle Act states that...
So, I mean, is your submission that driving in a parking lot is, let's suppose that she was in a car, in a parking lot, with a lower speed limit, where everybody knows that the speed limits are low. I mean, you're not suggesting that she shouldn't be liable to mandatory minimum if she were in a car.
No, we were talking about the harm that...
Right, and my suggestion is the mere fact that you're in a parking lot doesn't mean there's not harm to be caused. There's cars on roads. This is the reason why driving on the road is important, because roads are dangerous places. There are cars, even if she doesn't cause the harm, somebody swerving to avoid her or slamming on the brakes could cause a lot of harm. Death can occur even in parking lots, serious injury.
And the respondent says that the harm that could be caused is not as significant as a motorized vehicle, which is what the code aims to prevent by doing so. Because of the lower speeds, as this respondent has submitted. I'd like to quickly take you through the Oaks test, if you'd like to hear that.
I would suggest instead you just conclude, counsel. I think you don't have, I think the Oaks test is much conclude in, on your points.
So from the factors considered, we conclude that Mrs. Smith has been subject to cruel and unusual punishment. Based on the factors of the Latimer test, the wheelchair is not analogous to a traditional motorized vehicle. This situation should not amount to Mrs. Smith's third breach of Section 253, and she should have been charged with a lesser offense that would not subject her to a mandatory minimum sentence. This results in a breach of Mrs. Smith's right not to be subject to cruel and unusual punishment. So now my co-counsel will speak to the issue of constitutional exemptions.
Mr. Keynes?
Good afternoon, Justices. Again, my name is Justin Keynes, and I will be speaking on the issue of constitutional exemptions. The respondent submits that the trial judge was correct in determining that a constitutional exemption was the appropriate remedy for a breach of Mrs. Smith's Section 12 charter right. It was not the intention of Parliament to preclude users of motorized wheelchairs from engaging in typical social activities, and the trial judge found that Section 253 of the Criminal Code does just that.
Now, sorry, counsel, I hate to interrupt you so early, but how do you know what Parliament's intention was? How can you say that it wasn't Parliament's intention?
If we look at the answer from the debates of the legislature from the 16th of May 1921, when the initial offense was included, it said that the intention was to protect public safety and not to prevent them from engaging in typical social activities, which the trial judge...
Sorry, is that a quote? Could you say open, start quote, and end quote, just so I know what Hansford said and what your gloss is?
Hansard says, open quote, "The great gravity there is a man in driving a motor vehicle while in such a state as to not be able to control himself, to say nothing of the vehicle, and thus exposing the safety of the population." Close.
Doesn't say anything about typical social activities.
No, that's, as the trial judge found, that's what the law does, and that is not what is in the answer as the intention of the Parliament.
But again, it says motorized vehicles. It doesn't make a distinction between cars and wheelchairs or boats and wheelchairs. Right? It says motorized vehicles. That's what it says. And we have a case before us that says that a wheelchair is a motorized vehicle. Wheelchair is a motorized vehicle. So I'm not sure. I don't see where Parliament's intention was to exclude wheelchairs from this section.
Could I have a moment?
Sure.
The respondent submits that it is not the position of the respondent that they are analogous. We're saying that it is different because Mrs. Smith is relying on the wheelchair as her exclusive means of mobility, and that is in effect her legs, and so thus it is differentiated from what Parliament was attempting to address.
Now, counsel, another point, your submission then is that getting drunk is typical social activity.
The respondent submits that the trial judge found, as a matter of fact, that Mrs. Smith was being prevented from engaging in typical social activities.
It's not a matter of fact, though, right? That's obiter. Like she's kind of commenting on the case, but it's not a fact. Like her eyes are green or something. Like
There's no expert evidence on the amount, how often people get drunk, what proportion of the population get drunk, what proportion prefers to go and get drunk rather than go to a movie. There's no evidence on that.
Anyway, counsel, continue with that argument.
Thank you. I will take you through two main arguments this afternoon. The first is that from the case law, the availability of constitutional exemptions has not been conclusively decided, and thus remains a valid sentencing option for trial judges. And the second is that because of the standard of review, the trial judge's ruling should not be disturbed. The weight of the authorities surrounding constitutional exemptions seem to have peaked against their use with the 2008 decision by the Supreme Court in Ferguson. In that case, Chief Justice McLaughlin concluded that constitutional exemptions should not be recognized as a remedy for cruel and unusual punishment, and that if a mandatory minimum were to violate the Charter, that the appropriate remedy would be to declare the law of no force and effect under Section 52(1) of the Constitution Act. In Ferguson, Chief Justice McLaughlin stated for the court that constitutional exemptions cannot be granted on a case-by-case basis, and highlighted two powerful arguments as to why constitutional exemptions can be favored. The first is that it is better to grant a constitutional exemption where a law has been found to be constitutional in its general application, but unconstitutional in a small number of cases. And this is what is happening in the case at bar. There's no disputing that protecting society from intoxicated drivers in motorized vehicles is of great importance. In this case, though, Mrs. Smith was paralyzed and had no choice but to use this vehicle. She was traveling